What if the green card application you submitted months ago, maybe even years ago, is now sitting in a category that no longer works the way you thought it did? What if a single policy shift, one that happened quietly inside a federal agency building in Washington, just changed the rules for hundreds of thousands of people waiting in line right now? I know that sounds alarming, and I want you to stay with me here because what we are covering today is not a rumor, it is not speculation, and it is absolutely not something you can afford to scroll past. There has been a significant operational change at USCIS affecting family based and employment based green card processing. And if you or someone you love is in the pipeline right now, the next 12 minutes could save you from a costly mistake. Welcome to Immigration Path USA. This channel exists for one reason: to cut through the noise, the misinformation, the Facebook group rumors, and the WhatsApp voice notes that get half the story wrong and give you a clear, structured breakdown of what is actually happening in U.S. immigration policy. We do not sensationalize. We do not fearmonger. We explain. Before we go any further, I do need to share something important with you. I am not an attorney. Nothing you hear on this channel is legal advice. Everything we discuss here is for educational and informational purposes only. Your case is unique, your circumstances are specific, and you should always consult with a licensed immigration attorney or accredited representative before making any decisions about your application. Now, with that clearly on the table, let us get into what is happening. USCIS recently announced an operational policy adjustment that affects how certain priority dates are being processed across multiple visa categories. This is not a new law passed by Congress. This is an internal operational shift, the kind that does not make front page news but lands like a quiet earthquake for the people directly in its path. The decision came from agency leadership at USCIS, in coordination with guidance from the Department of State, and it touches the I-485 adjustment of status process, the I-130 petition for alien relative, and in some situations, the I-140 immigrant petition for alien workers. To understand why this matters, we need to walk through the three layers of this change: what it is, who it affects, and when the impact begins to be felt. Let us start with what. USCIS has tightened its interpretation of what it means for a priority date to be current and therefore actionable. For years, applicants have relied on the visa bulletin published monthly by the Department of State to know when they could file. There are two charts in that bulletin: Chart A, which is dates for filing, and Chart B, which is final action dates. The difference between these two charts has historically given applicants in certain categories a strategic window to submit their I-485 before their number was fully current, locking in their place in line and getting into the system faster. What USCIS is now doing is narrowing when it will allow applicants to use Chart A for filing purposes, particularly in categories where visa backlogs have grown significantly. In plain terms, some people who thought they could file now may have to wait longer than expected. Now, who does this affect? The most immediate impact is felt by applicants in the EB2 and EB3 employment-based categories, particularly nationals of India and China, where the backlogs are measured not in months, but in decades. But here's the catch that most people are missing. This change does not stop at employment-based petitions. Because of the way visa numbers are allocated and shared across categories, a tightening in one category creates downstream pressure in others. Family-based applicants in the F2A category, which covers spouses and children of lawful permanent residents, are also seeing ripple effects. When one line slows down, the pressure redistributes, and people who thought their wait was finally ending are finding themselves looking at extended uncertainty again. When does this start to matter in real time? That is the question everyone is asking, and the answer depends heavily on your specific category, your country of birth, and whether you have already received a notice of action on a pending I-485. If you filed before the policy shift and received your receipt notice, your position in line should be protected. If you were planning to file based on the April or May visa bulletin and have not yet submitted, you need to verify right now. Today, not next week, whether the filing chart you were relying on is still active for your category. This is where it gets critical for anyone waiting on a green card. The operational shift we are describing does not change the underlying law. Congress has not passed new legislation restricting immigration in this specific way. What has changed is the agency's internal posture, how it is choosing to administer and interpret existing authority. That distinction matters enormously because it means this could change again. Policy implemented through agency guidance can be reversed through agency guidance, but it also means there is no guaranteed timeline for when things normalize, and in the meantime, real people are being affected in real ways. Let me tell you about a family. Let us call them the Ramirez family because the details of their situation reflect what thousands of people are living through right now. Maria and her husband, Carlos, have been waiting for nearly 4 years on a family based petition filed by Maria's U.S. citizen sister. They are in the F3 category, married sons and daughters of U.S. citizens. They have been watching the visa bulletin every single month, tracking their priority date like a second job. 6 months ago, they were told by a notario, not a real attorney, a notario, that their date was close enough to start gathering documents and that they could probably file within 90 days. They spent money. They gathered paperwork. They took time off work to get medical exams done through a USCIS civil surgeon. And then the bulletin shifted. Their category retrogressed, meaning the date moved backward, not forward. And now they are looking at additional months of waiting with money spent and no application filed. The Ramirez family situation is not unusual. It is the result of a combination of factors: a misunderstanding of how the visa bulletin works, reliance on unlicensed advice, and a policy environment that is genuinely difficult to predict right now. But there are things they could have done differently, and there are things you can do right now to protect yourself. That brings us to the action plan. Step 1 is to verify your priority date and filing eligibility directly from the source. Do not rely on third-party summaries, social media posts, or unofficial translations of the visa bulletin. Go to travel.state.gov and read the current bulletin yourself or have a qualified professional write it for you. Know which chart, A or B, USCIS has authorized for your specific visa category this month. USCIS publishes this authorization on their own website every month when the new bulletin drops. These are two different sources and both matter. Step 2 is to audit your document readiness without submitting prematurely. One of the most common and damaging mistakes people make is rushing to file before they are truly ready because they are afraid of missing a window, or filing before a window actually opens because someone told them it was fine. Gather your documents, your birth certificates, your marriage certificates, your financial sponsor's I-864, your passport photos, your civil surgeon's I-693. But do not pay filing fees or submit until you have confirmed in writing, ideally with a licensed attorney, that your date is current under the chart that USCIS has authorized. Step 3 is to protect yourself from scams and unauthorized practice of immigration law. The notario problem is real. Across the country, people operating under the title of notario, immigration consultant, or visa specialist, titles that have no legal standing in the U.S. immigration system, are collecting money, filling out forms incorrectly, and leaving families in worse situations than when they started. If the person helping you cannot show you a state bar license or accreditation from the Board of Immigration Appeals, they are not authorized to give you legal advice. Period. Scams in this space intensify every time there is a policy shift because confusion creates opportunity for bad actors. Stay alert. Now let us talk about what comes next in the broader policy environment, because this is not happening in isolation. Congress has been in ongoing negotiations about immigration reform, and while comprehensive legislation remains unlikely in the near term, there are targeted proposals moving through committee that could affect visa number allocations, per-country limits, and processing priorities. The per-country cap issue in particular, the rule that limits any single country to no more than 7% of available green cards in a given year, has been the subject of proposed legislative changes that have died in the Senate before but continue to be reintroduced. If any version of that legislation were to pass, the impact on Indian and Chinese nationals in employment-based backlogs would be transformative. It would not happen overnight, but it would signal a structural shift in how long the wait actually is. On the court side, there are several pending cases in federal circuit courts challenging aspects of USCIS's administrative authority and the way it interprets filing windows and priority date policies. The outcomes of those cases could constrain or expand what the agency can do through internal guidance alone. This is why working with someone who tracks litigation, not just policy, can make a meaningful difference in how you plan your case timeline. The bottom line is this: the U.S. immigration system is a moving target right now. It has always been complex, but the combination of agency level policy shifts, legislative uncertainty, and an increasingly aggressive enforcement posture from DHS means that the margin for error in your case is smaller than it used to be. Waiting for things to become clearer before you act is sometimes the right move. Acting impulsively because you are afraid of missing a window is often the wrong one. What is never wrong is staying informed, staying connected to licensed professionals, and making sure that every move you make is grounded in verified current information. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration Path USA right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential.